There have been lots of successes this year on the DPC front, and we're going to go over a few policy updates here first. June 2014, when I first started putting a map together, we only had 125 DPC clinic locations I could find across the country, and that's fewer than 125 practices because several of them had multiple locations. And it's gradually grown over the years. By July 2015, we were up to 290, September 2016 up to 445, and then most recently right around 620. So a lot of success there. The growth curve is a little bit more linear than exponential, but we're getting there. Where's the legislation been? When you first open up a DPC practice, at least back in 2002 or so, when about 3 or 4 of them that were publicly known were going, I'm sure there were many more, you get unwanted attention from the insurance commissioner. The insurance commissioner sees what you're doing and says, this smells a lot like insurance to me. What if too many patients came in? You couldn't possibly provide all these services that you're saying you could do, and I want to regulate you because of that. So Vic Wood, who's a DO grad of same school I went to in Lewisburg, West Virginia, started doing this in Wheeling, and all by himself fought for a law back in 2006 that was a narrow exception where he was basically allowed to keep his practice open, but they gave their healthcare authority the ability to set his prices, how he could advertise, who he could advertise to. It was incredibly restrictive. So not a good example. 2007, we had a much better example out in Washington State. That's mainly due to the efforts of Garrison Bliss, and the Affordable Care Act later referenced that law. 2011, Oregon, which was right next to Washington, instead of looking to Washington for guidance, instead looked to West Virginia and had a similarly bad law. 2012, Utah came along, and 2013, really nothing happened. In 2014, we get a lot more interest. Arizona has a short and sweet law, but it fails to really do anything of purpose because it doesn't explicitly state that DPC practices are not insurance, which is the main point of passing this legislation defining direct primary care. Louisiana was modeled after Washington, and then we had some discussions in other states, but nothing really happened. 2015, quite a bit more growth. We had our first governor that decided to veto DPC law, which was Montana. 2016, we had a veto in Virginia, but otherwise we're doing good. Several states were interested there. You can see them in various shades of blue. And then now, and we're up to 23. Most recently, Maine passed their law this year, and we did a pretty good job with it. I think, what's our win-loss record this year? I think we're 8-4. And that's without any real funding. It's just a bunch of grassroots efforts, just like we had here in Kentucky. Kentucky was the first state to pass a DPC law in 2017, and it's an excellent example. I've got, there's a handout in your packet. The first words at the top of it are unofficial copy, but that's the Kentucky DPC law we'll go over in a minute. But we had, so if you'll notice, if I back up just one state here, we also had West Virginia was red, Arkansas was red, now those are green. So we had 2 corrections and 6 more states that passed DPC law this year. South Carolina and Florida were pretty sad stories where there was a lot of effort but ultimately got killed in the committee. But the rest of them did pretty well. So what does Kentucky's DPC law say? So if you pull it up in your handout, it's really just 2 pages, one front and back there. It's got an excellent definition of direct primary care, and it has some helpful mandatory disclosures, which are good when you say, what should I put in this contract? It sort of gives you a little easy guidance and also makes it more likely to withstand any judicial scrutiny. If we're sort of looking down page 1, when you come to line 12, that's what I would call a no double dipping prohibition. That's pretty important. It distinguishes DPC practices from concierge practices. Concierge really doesn't have a legal definition, but it's typically a fee for non-covered services practice. And DPC physicians, of course, don't need to play those games since we're not dealing with insurance, at least for DPC patients. You've also got some refund provisions and a mandatory disclosure provision. Kentucky's is worth noting because they include a statement that has to say this is not a health benefit plan, and also a statement that says it is not an Affordable Care Act qualifying plan. People often confuse that because the ACA does mention direct primary care. It does reference the Washington state law and basically borrows their definition of it. And then it says you're allowed to buy a high deductible plan you otherwise would not be allowed to buy. But DPC by itself does not get you out of the tax, as John Roberts would say. So broad primary care definition was included, which was nice. And then something that was a little bit different, if you look at page 2, lines 13, 14, 15, third party does not include a network designated to merely accept payment from a patient and then direct the patient to one of several independently owned clinics for delivery of care. So I won't mention them by name, but there were a few DPC outlets that sort of came and went that were trying to do that and become yet another middleman, and here they're saying they don't like that. So if somebody other than the patient's going to pay a fee, it basically needs to be a family member, legal guardian, or an employer. Okay. Kentucky is one of only 2 states that have this kind of Medicaid problem. What did they do? Well, they were worried that, as we just heard a wonderful talk about how Medicaid didn't necessarily pay the physicians that well, at least not the managed care outlets. They had a lot of physicians who weren't willing to see Medicaid patients at that rate, but they were willing to see them for cash pay. And so the state of Kentucky came in and said, no, you can't do that. If somebody has signed up for Medicaid, it is illegal to privately contract with them in the state of Kentucky. This is due to the prior governor's executive order, and it has not yet been changed. The only other state to make this mistake so far that I'm aware of is Colorado. So there's an article in Journal Legal Medicine that should be coming out in about a month or so that sort of summarizes at least where the laws were at the end of 2016. The publication process takes a long time, so unfortunately it kind of dragged their feet getting it out, but it will be out there if anybody wants more detail on that. So what else are we going to cover today in terms of going on the legal offensive? Restrictive covenants. DPC physicians often want to know how to get out of whatever hospital contract they're under, and that's easier in some states than others. How you can leverage your out-of-network status, getting rid of the PBMs, the pharmacy benefit managers that are wasting lots and lots of money in our healthcare system. And then one of the more common questions I've had recently that seems like it's not discussed much is, does HITECH let you play some more contractual games or not? So when it comes to restrictive covenants, non-competes, hospitals love these things, and they like to intimidate physicians with them, and they're often totally unenforceable if you look at the details. So courts don't like them. They're against public policy. If they're going to be withheld, then they need to protect some sort of legitimate business interest. And there's a lot of variance from one state to another. But they go through a reasonableness test. They compare the business interest versus the employee hardship and how much the public might be injured if this thing were enforced. And then they look at common requirements in terms of the scope. So if I'm an employer and I want to intimidate you into not leaving, I might say you can't work anywhere within 100 miles and you can't do any form of family medicine at all. And this is for 20 years. And when you get really aggressive and ridiculous like that, the court's less likely to enforce it than if it were 5 miles in 6 months and only urgent care, which might have been what you were doing. So everybody always ignores Alaska, so I thought I'd pick a nice case out of Alaska here. This is sort of on the more friendly side of things. They looked at a reasonableness test here and said, in this instance, in this case, this Metcalfe case, it was unenforceable on grounds of public policy due to feared injury to the public. And they went on and gave a little bit more detail. This case, however, presents a rare instance where a party is attempting to enforce a covenant not to compete against a person employed by a federally funded nonprofit organization that provides free or low-cost healthcare services. In such a case, competition will not be presumed and must be proven. So I think you could make that analogy if you're a physician that's leaving a large hospital system that's either nonprofit or what I would call non-tax paying, and you're not going to compete with them, you're going to do DPC. They don't do DPC, they don't serve low-income patients, which you'd be serving in that setting. So I think we have excellent precedent in Alaska, at least for the 2 DPC practices that are operating there. They went on, it appears from the record the defendant is employed by an organization providing an important low-cost service to a population in need of such care. Then they voided it for public policy reasons. But we're in Kentucky, so let's focus on a Kentucky case, which unfortunately was not as rosy. This was at Daniel Boone Clinic out of 1987. And the court said there's going to be no inequity that would result from enforcing a restrictive covenant, and the patients were not third-party beneficiaries to the restrictive covenant. So unlike Alaska, where they were worried about patients having access to care, at least in Kentucky, they said, no, that's really not the issue. You have a contract with the clinic has the contract with patients, so when you leave, they're just going to send them to another doctor, so who cares if you have a problem? It's a little bit depressing. So take away, at least in Kentucky, don't try to make the public policy argument because it's likely a loser. There may be some other ones that you could employ, but we're not going to get into the details of it here. In general, if you're signing an employment contract, these are things you want to pay attention to. So non-competes we just went over. Note the states there: California, Montana, North Dakota, South Dakota, Delaware, and Massachusetts. They are prohibited. So if those are in place at all, it's a joke. Not going to happen. There's a restrictive statute that says exactly what you can do in terms of boxing somebody in Florida, Idaho, Michigan, Oregon, Georgia, and Colorado. And then there's clear physician favoritism in Virginia, Tennessee, and Texas. The rest of the states, they're kind of too specific to attempt to summarize in a meaningful way. Things that I commonly tell people to look for when they're signing any contract, be it DPC or hospital or otherwise, is get an accurate job description. The more precise they are, the more that works in the physician's favor. If they're vague, then they can dump a lot of administrative tasks on you that you may not want to do and say that this was just part of your job. Same thing with the schedule. The more accurate and precise they are, the more that tends to help the physician. Moonlighting, you want to retain the option to do so. If you are one of the folks who's working in some sort of RVU setting, usually the numbers don't work out in your favor too much. The more you chase those, you really don't get ahead and you just get burnt out more. If you want to actually make extra money, you're probably better off moonlighting somewhere else rather than chasing the RVUs. Research rights. This is weird. I've seen lots and lots of hospitals try to retain full rights to anything you would come up with. I mean, it's like if you're the next Stephen King, they want the rights to your novel. Don't sign that stuff away. It's ridiculous. Malpractice tails. You want to avoid these. This is often used as yet another hidden penalty. So the way somebody might try to tie you into a contract is they give you a signing bonus and then they want a lot of it back if you leave early. Another way to catch you is a malpractice tail. They want you to pay for your own tail coverage. That's, of course, if you had what's called claims-made coverage. Better yet, get them to have occurrence coverage, and then there is no tail problem at all. Okay. So when we come to out-of-network, the network definitions are what kind of get you in trouble, and they're worth talking about. So networks define your allowable fees. They define what your medical services are and should not be. They define medical necessity, and, of course, they make you deal with prior authorizations. So the network shall tell you where to refer, tell you what to prescribe, tell you what's medically necessary and what's not, tell you how much professional liability insurance you should have or not have. And of course, as Dr. Huntoon talked about earlier, they can dig into your records even if you didn't want them to. And that's one of the reasons you want to be DPC and sort of out of network, is you have this increased privacy. So when you're out of network, you get to set your own fees, decide what your scope is, and decide what you want to do. Dr. Greg Zydiak was at a prior AAPS conference and gave an excellent lecture on prior authorizations. You definitely should look that up. He's got legal precedent that he highlights, and he sort of shoves that back in their face every time they ask for a prior auth, and he doesn't waste his time with it at all, and the majority of his are approved. Okay. So if you're out of network, you have the ability to go public, and that's sort of the easiest way to get at these guys, because you couldn't do that if you signed a contract with them. So if they say something stupid and your patient wants to join you in it, let's embarrass them. If they refuse to approve a head CT on a kid who's fallen off a bike, and they want to go public with it, then they can. They can't stop you. They have no contractual right to get at you for that. So that's the first one. It's the easiest. Focus on their delays in their care. So document all these things and sort of prove how much they're delaying it, and it could help your patient if your patient ever tries to sue them, which we'll get into on the next slide. Patient can become a plaintiff if the plan is purchased outside of ERISA. Unfortunately, if it's under ERISA, we've got a hurdle there. If the deductible's been met and they're not approving things, send them to the ER. This is going to tag the plan with more expense. So if we teach them how to behave, maybe eventually they will. So how does ERISA affect a DPC practice? So the first thing is it affects your patient, maybe more than you. So ERISA is the plans that basically if you're these things grew because of several different laws, most recently the Affordable Care Act. So if you're under an employer-sponsored plan, darn good chance it's an ERISA plan. And part of the reason these things are so popular is because they don't have to deal with state variance in insurance law. It's all federally regulated and federally set. So if I'm some large company like Walmart and I want to have one consistent plan, I'm able to do so under ERISA. And one of the reasons they like it is because if the plaintiff patient had a procedure that was denied and it's under ERISA, then the only damages they're going to get is whatever that procedure cost. That's it. It's kept quite low. And if they bought it outside of ERISA, if they bought it on the exchange or some other forum, then you can get at the plan for quite a bit more money. So that's good to know up front. And this is the immunity example. I guess I sort of jumped ahead of myself there. So applies to employer health benefit plans. States may not regulate self-insured plans, and ERISA gives a right of action to an insuree against an insurer, but limits the recovery to the value of benefits provided in the plan. So that's why when I first studied this in law school, I grew up hating ERISA. It does have some provisions that are helpful to us, but not on an individual DPC basis. Okay, when it comes to the pharmacy benefit managers, how do you deal with those guys? You bypass them as often as you can. So the PBMs are a problem because they play spread pricing games. They hide rebates that they receive, and they make a lot of money and they never disclose it. And they really didn't do their main job. Their job was to lower prices and provide better transparency, and instead they just negotiate, middleman discounts for themselves and leave everybody else none the wiser. If you're prescribing a medication and the patient is getting it paid for through their insurance, they used a PBM. One way or another, they used one. So to the extent you can get them to go outside of that, do it. For DPC practices, that usually means dispensing medications. The next slide will show you that there's some states where that's much more difficult or impossible. If you can't do that, at least use GoodRx. And I would encourage you to really emphasize to your patients that if the price is anywhere close with GoodRx to the regular plan, go ahead and use GoodRx. Thumb your nose to the plan as much as possible. Use an independent direct pharmacy that's just going to offer you cash pricing. And then medical tourism is an option. I've got an example of that coming up. So again, go to the plan as last resort. In-office dispensing, where can you do it, where can you not? If you're in a green state, it's no problem at all. If you're in a red state, and I actually need to update this a little bit. Utah is actually more yellow, and New York is a little bit more yellow as well than they are red anymore, but the exceptions are pretty narrow. In Utah, they changed the law late in 2014, 2015, and if you're doing an on-site clinic for a large employer, then you're basically allowed to dispense what you want. If you're an independent DPC practice, it doesn't really help you. Oh, one more thing I should back up here. On this slide, I mentioned that there's a Kentucky handout on dispensing requirements. So that's the other page that's stapled to the Kentucky law. It's kind of hit or miss whether or not the state will give you definitive guidance like this. This two-pager is not bad. Georgia actually has really good guidance if you're looking to sort of build your own policies. And I've got that linked on DPC Frontier. I'll mention here, at least on item 4, where they call it record keeping and dispensing requirements for physicians who dispense at Kentucky, they say, so this is worth noting, repackaging of drugs, i.e. taking drugs from a large container and placing it into a smaller container before dispensing in advance of need may require separate licensing. I haven't found where this separate licensing exactly would be, and I also am not sure what their definition of in advance of need is. So be careful of that. If you're trying to be extra conservative, what you do is you get them from Andameds or some other supplier in the exact quantity you need, and then you don't need the pill counter and you don't need to worry about that provision. So HITECH. This is where I've had the most comments recently, and I've not really spoken about this previously, so hopefully I can have this make sense. HITECH modified HIPAA, and it set forth certain circumstances in which a covered entity now must comply with an individual's request for restriction or disclosure of his or her protected health information. And you got the CFR citation there in case anybody doubts you. So the way DPC practices should be able to use this is you can go to a specialist who doesn't want to give you a cash price, maybe because they're in the regular system, and say, wait a minute, there's a way to do it. So what does HITECH really say? It says that the covered entity must agree to the requested restriction unless the disclosure is otherwise required by law. So that's obviously an important phrase that we'll dig into a little bit more. What does otherwise required by law mean? And let's see, if the request for restriction is on disclosures of protected health information to a health plan for the purposes of carrying out payment or healthcare operations, and then we come down below, for which the healthcare provider has been paid out of pocket in full. So, nutshell, if the patient wants this to stay private, doesn't want it to go to the plan, and is going to pay for this entire procedure, consult, whatever, out of pocket, then you have to listen to them, okay, unless there's an exception to this provision, and not send it to the plan. So you have to be able to segregate that in your medical record so that you don't send it to the plan later, so on and so forth. So the problem is, if I'll back up here briefly, is that we have that provision that said the covered entity must agree unless otherwise required by law. So where does the otherwise required by law hit you? It can hit you with the state's Medicaid law. It can hit you with the state's HMO laws. So unfortunately, what looks like it could have been a broad sweeping provision in HITECH actually was sort of castrated a bit, because they basically said if there's a conflict of laws here, the other law is going to trump this one. And that's the unfortunate answer I have to tell DPC physicians all the time, is that it's not as a panacea that you would like it to be. So you're going to look for an exception here, but so the key thing to note is you're going to go to your state law, your state insurance code more specifically, and see what it says HMOs have a right to. Because the HMO is going to put it in their contract that you're not allowed to do this. But whether or not it matters is whether or not it's in state law. Because HITECH will trump that private contract, but it won't necessarily trump state law. In fact, they've said that they wouldn't. Same thing with Medicaid. So in Kentucky, for example, this wouldn't work because Medicaid's not going to let you do it. Medicare, however, it will work. So they actually said Medicare is subject to mandatory claim submissions, provision of Section 1848G4 of the Social Security Act. But, oh, by the way, we're going to go ahead and give you an exception. Even though Medicare law, based on our writing, would trump HITECH, we're going to say that a Medicare provider is not required to submit a claim to Medicare for the covered service and may accept an out-of-pocket payment for this service from the beneficiary. However, the limits on what the provider may collect from the beneficiary still apply. So we'll dig into what that really means here in a second. When it comes to HITECH implementation logistics, so you want to have the patient sign a request that the information relative to self-paid services is not going to be disclosed, i.e. you've got to sort of segregate it from everything else so that you don't accidentally send it to another covered entity, be able to flag it that way. And then there were HHS comments on this, so fortunately, because it'd be darn near impossible to do, it's not on the physician to make sure that this information stays private through the rest of the downstream chain. So what do I mean by that? Pharmacies, lab specialists, if you send an electronic prescription over and they don't want the plan to know that they've been prescribed this medication, then they need to show up at the pharmacy quickly and say, don't tell anybody. And the way some physicians try to make that a little more secure is that you just write it on paper. And that way the patient can show up right away and there's no risk that they would accidentally submit it to the plan. Okay, HITECH privacy summary. So all covered entities must have some sort of process to allow these patients to pay privately of their own free will to keep the information private. Medicare, the law would trump HITECH. However, they provided an exception anyway. Medicaid's going to be state specific depending on whether or not they allow it. HMO laws are the same way. And then any kind of private insurance contract, HITECH, of course, is going to trump that private agreement. So it gets you out of those. So what about Medicare? If we come back to that, how can you play with this in the Medicare setting? So I've had people ask me, can I just use this as a route to privately contract and then not opt out? Theoretically, that's possible, but I don't recommend it. So you could continue to be a participating physician. You could attempt to charge all your Medicare patients privately for covered services, but you're going to have to code, and you're going to have to respect that Medicare limiting charge. And then you're going to have to prove that you use the appropriate charge if somebody wants to audit you. It might be a suspect a little bit if all of the patients are signing up for this and it's supposed to be of their own free will. I think it's a little bit easier if you focus on what Andy said earlier and you're sort of advertising based on the fact that you're private pay, that maybe your charts are on paper and things are all, very, very secure. But theoretically, you could have a patient who showed up and claimed they didn't care about that and that you wouldn't let them go ahead and proceed with regular payment. So yeah, for those reasons, it's a very clunky attempt at an alternative to opting out that I don't recommend pushing. The last bullet there, this is actually the place that's maybe most interesting to me. So some physicians have tried to make a fee for non-covered services argument for their membership fee. It's common in the concierge space, and the concierge physicians will say, the membership fee is only for non-covered services. I'm still going to bill you for all those covered services on a fee-for-service basis. And some DPC physicians see this and they say, well, I don't want to opt out because I still maybe want to work in another setting. I want to work a hospitalist on the weekend, so I'm not going to opt out. And for my Medicare patients, I'm just going to do a fee for non-covered services agreement. The problem with that by itself is then you have to be able to look at Medicare with a straight face and tell them everything you do is a non-covered service. Because in situation B, you weren't still billing them on a fee-for-service basis because you didn't want to deal with that hassle. Does everybody follow that? Okay. So here's where you can play with them. If you're trying to do that, you could theoretically use this to make your non-covered services argument a little stronger, because you could take this provision and say, I'm still charging you for those covered services on a fee-for-service basis. My patients just elect to pay privately because they want additional privacy. Or they elect to pay on their own because they want the additional privacy. Does everybody follow that logic? So that's where you can kind of play with that there. If anybody has any questions, I'll be happy to answer them. I think we have a panel coming up for it. Okay. So that's it.